Hello, everybody, and welcome back to SEC Roundup. My name is Nick Morgan. I'm a partner in the Investigations and White Collar Defense Group at the law firm of Paul Hastings. And this week, our special guest is Professor Jim Angel. Professor Angel is at the Georgetown McDonough School of Business. And Jim, you and I had an occasion to work together on a recent amicus brief, and I really appreciate you coming and joining us today on SEC Roundup.
Why, thank you. It's an honor to be here.
So for those who may not be familiar with the issue that we raised in the amicus brief, I just give a quick backgrounder. So this related to Grayscale's application to the SEC to turn the Grayscale Bitcoin Trust into an ETF, or exchange traded fund. The people who are sort of following the space know the SEC denied that application at the end of June, and Grayscale went to court, in this case to federal appellate court in the District of Columbia, and they filed essentially a lawsuit challenging the SEC's denial of their request. Their brief by Grayscale was 100 pages, but there are a number of people who don't represent Grayscale and have no direct economic interest in Grayscale's application who were very interested in the issue. I think there were something like 11,000 letters submitted to the SEC at that stage of the process. So when it came time for the court proceedings, there were a number of parties who filed amicus briefs. Those are briefs that are friend of the court briefs, not by parties, but by non-parties who want to share some insight with the court. And Professor Angel and I worked on an amicus brief together that we filed on behalf of a fairly large group of people, including a number of academics, Professor Angel included, a number of former regulators, including Harvey Pitt and Joe Grunfest. And we were trying to collectively make a point about the SEC's decision to deny Grayscale's spot Bitcoin ETF when the SEC had previously approved futures-based Bitcoin ETFs. And Professor Angel, if you could just maybe describe for folks, what was the point that you and the other signers on this amicus brief were trying to make to the court about this process?
Well, my point was that there was no real economic difference between the spot ETF and a futures-based ETF, that the futures prices track the spot prices so closely that there's really no economic difference between these two products. So the SEC is being completely arbitrary and capricious and stupid by not approving the spot-based ETF and approving a futures-based one.
There was a suggestion or some discussion around possible manipulation of the spot market that might or might not also have been present in the futures market. What do you think about that risk of manipulation in one versus another?
Again, the two markets move up and down so closely together that any manipulation in either market is going to be represented in the other market. So there's no real economic difference between the spot and the futures at this point.
Okay, terrific. Well, we'll leave it there, and we'll put in the comments field below the video a link to the amicus brief and some other materials about the case in case anyone is interested in reading more. Professor Angel, thank you so much for joining us, and everybody else, we'll see you on the next SEC Roundup.